HMRC stands accused of breaking the law, according to The Telegraph, which says that it's seen guidance that says HMRC is allowing trans staff into women's toilets in defiance of the Supreme Court ruling. Campaigners say that they are acting unlawfully in its guidance to employees, which The Telegraph says it has seen. And for what it's worth, I agree, for reasons that I will explain in this video. First of all, please do subscribe to the channel. That really does help. Helps more than you know, as does liking the video with that little like button below. Thank you so much. So let's take a look at this, shall we? Because it would be true if this guidance says what they say it says. It would be true that it is in defiance, direct defiance of the Supreme Court ruling, which in my view was absolutely clear. Now, whilst many companies have said we're waiting for the guidance as to what we're supposed to do, I think it was absolutely clear. The judgment was long. There was a lot of detail in it. I've been through it in many videos. I've explained it. I think it was perfectly clear. There are, of course, those that say that it wasn't so clear and therefore we need clearance on it. And some people even saying that it needs to be reheard, but that's just not going to happen. So let's take a look at what it actually says here. So this document apparently released to employees by HMRC is titled Gender Reassignment, Getting Ready for Your First Day in Your New Role. Seen by The Telegraph outlines how employees should feel respected in the workplace after transitioning, which is absolutely fair enough. But then it goes on to say, after they obtained it for Freedom of Information request, goes on to say, this will be your first real day at work when you come in your new identity, hopefully for the rest of your life. Again, fair enough. But then it goes on to say, you can then expect people to treat you in your new identity, fine, but use the toilet appropriate to your new gender and people to call you by your new name. Now, there's all sorts of discussions, I suppose, as to whether people should be expected to use a new name for somebody. I mean, it would be perfectly respectful to do so, but some people may have philosophical views and beliefs against doing that if they just simply don't believe that somebody can change their gender. Now, it's fair to say right at the outset that if I go to the bottom of this document here, it's fair to say at the outset that an HMRC spokesperson said, we comply fully with all existing statutory guidance. As and when this guidance is updated, we will, of course, comply as it legally required. Now, I have a criticism to make of that because it's not necessarily just what is definitely not just the statutory guidance with which HMRC should be complying, but the law as it is, and the law as it is written and decided and ruled by the Supreme Court. They should be expected to be able to read the judgment by the Supreme Court and understand what it says and comply with that and apply that retrospectively to the previous and existing law. And I say retrospectively only in a sense that this is what the Supreme Court said was always the case. It's not that there's not to be confused with. There's a ruling and then it changes how things were applied in the past. It just said this is how it always was. And the finding was thus. The Supreme Court said here quite clearly on the summary of the Equality Act 2010, and just to remind anybody what this really was about was to how the term sex, man and woman, were applied and defined and understood in the Equality Act and, of course, the Sex Discrimination Act and so on. And it says here, in summary of its findings, for all these reasons, this examination of the language in the Equality Act 2010, its context and purpose demonstrate that the words sex, woman and man in sections 11 and 212, subsection 1, mean and were always intended to mean biological sex, biological woman and biological man. These and the other provisions to which we referred cannot properly be interpreted as also extending to include certificated sex without rendering them incoherent and unworkable. In other words, and the Supreme Court sought necessary to clarify precisely what it meant. In other words, in relation to sex discrimination, for the purposes of Section 11 and 212, a person with the protected characteristic of sex has the characteristic of their biological sex only. A trans man with a GRC, i.e. a biological female but legally male for the purposes to which Section 9 of the GRA 2004 applies, is a woman for the purposes of Section 11. And a trans woman with a GRC, that is to say a biological male but legally female for the purposes of Section 9, is a man and not entitled to be treated as a woman under the Equality Act. This conclusion does not remove or diminish the important protections available under the Equality Act for trans people with a GRC, as we've explained. To the contrary, this vulnerable group remains protected in the same ways we've described. And so, in other words, if an employer were to say you are treated badly because you are a trans person with a GRC, and this is how we are treating you differently, that would be bad. That would be discriminatory. But what it says here, that if someone is a man or a woman under the Equality Act, and for the purposes of the law, as it always was, it's based on biology. And so now if we turn to, well, how does this apply in the workplace? Because this law has always been around as well. There has, for a long time, since 1992, been provisions for sanitary conveniences. Under the Workplace Health, Safety, Welfare Regulations 1992, there are several sections that apply to these sort of separate spaces. First of all, sanitary conveniences under Section 20. Suitable and sufficient sanitary conveniences shall be provided at readily accessible places. So just to make clear, these are for employees of the company or for the public body and so on. Without prejudice to the generality of this paragraph above, sanitary conveniences shall not be suitable unless the rooms containing them are adequately ventilated and lit, they are rooms containing and kept in clean and orderly condition, and separate rooms containing conveniences are provided for men and women, except where and so far as each convenience is in a separate room, the door of which is capable of being secured from inside. So, in other words, they have to be separate spaces for men and women, save that it may be necessary to have them in a separate room with the door capable of being locked from inside, separate locked cubicles. It may be the case that that is what HMRC is doing. If not, and it is just as that guidance that we just read suggested, we're talking about this third highlight bit down here, use the toilet appropriate to your new gender. If they are just saying that a trans woman can use the women's bathroom facilities, that, in my view, would be unlawful. And this section here for sanitary conveniences is under Section 20. We can skip ahead to Section 21, or Regulation 21, which is washing facilities. And again, they are to be separate, provided for men and women there. And if we go to the address bar here and change it to 24, we can look at 24 as well. And this is for changing clothing. So changing rooms, they again are to be separate facilities for men and women where necessary for reasons of propriety. And so quite simply, they need to be separate spaces. This is why I say when the Supreme Court ruled that sex, woman and man are based on biology in the Equality Act, as it always was, and for the avoidance of doubt, anytime sex is mentioned in legislation, we go right back to the Sex Discrimination Act. And so everything that refers to sex, man and woman, it's to be based on biology. And so whilst some say that there are some reasons for guidance and clarity and so on, I personally think it was clear enough. Yes, it does create certain problems, but this, I say, was clear enough. And so if they are only now saying that they use the space that is appropriate to their new identity, that is potentially problematic for HMRC. Now, they do say that if there's new guidance, they will comply with that. But in any event, the interim guidance thus far from the EHRC has said that trans women should not be using women's facilities and trans men should not be using men's facilities. So I would agree on the face of it with the Telegraph, with the campaigners, that it appears that HMRC may have a problem here if that is the guidance that they are currently following, that permits trans people to use the bathroom of their new identity. And just to go back to the interim guidance from the EHRC here, it does say that toilets, showers, changing room facilities may be mixed sex where they're in an appropriate room lockable from the inside. And that is because that complies with the regulations that I just showed you, save that in situations where they can have a room which is lockable from the inside, thus precluding any possibility that they're in the same room with someone of the opposite biological sex. So I found that quite interesting. If you did too, please do leave me your comments below. Please do like the video and subscribe. And as always, thank you for watching.